planning attorney that holds his CPA, JD, and LLM. He has over 40 plus years of experience as an estate planning attorney practicing in St. Louis, Missouri. He was previously a partner at the St. Louis law firms Thompson Colburn and Armstrong Teasdale. He has published 4 books and over 75 articles on various tax and estate planning topics, as well as multiple other books, if you've been hearing him speak here, on subjects ranging from Theodore Roosevelt and the 1904 World's Fair to St. Jacinta of Fatima. He's a frequent presenter at various tax and estate planning symposiums. And Jim has also served as an adjunct professor at the Villanova University School of Law graduate tax program and the St. Louis University School of Law. He is a graduate of Notre Dame Law School and the New York University Graduate Program in Taxation. And he currently teaches a course in estate planning for the UCLA Personal Financial Planning Extension Program. So without further ado, I'll let Jim take it away and get us started.
Okay, thank you, Mary. Just a little bit about my background, because I'm not sure everyone, even though I've been practicing over 40 years, I move around a lot as far as getting involved. I get involved in a lot of things, so I don't have that much time to get heavily involved in anything. So just a little bit about my background, in addition to what Mary talked about, is that it was about this time of year in 1981 when I was at Notre Dame and I was getting ready to start at Thompson Colburn. It was then called Thompson Mitchell. And I had just finished an estate planning course at Notre Dame. And what it was occurring to me throughout that whole course, because I'm also a CPA, so I have a tax background. What was occurring to me throughout that course, I go, wow, look at all these unfair, I call them unfair rules that we're applying to clients and their children. And I wanted to solve those, help clients solve those. That's why I wanted to go into estate planning. But I also knew that unless I have the strongest possible tax background, I'm not going to be able to do that as well as I want to. So kind of upset my law firm when at the last minute I said I'm going to NYU and got involved there. But when you're at NYU, it's interesting. When you apply to NYU, they only ask you one question on the application. They ask you, why do you want to come here? And that's exactly why I wrote down. I wrote down that I want to know the tax laws so well that I can help my clients get around these unfair. And you guys all know what they are. There's tons of them. But the worst one, right, is the maximum tax rates on trust at only $13,000 of income. That's incredibly unfair, even if the kid's 5 years old. So rules like that. So that's why I went there, and that's what I do today. I still do that today. So every article I've ever written, every book I've ever written always has that in mind. I'm talking about an unfair rule and how can we help clients get around it. Another thing I want to mention right at the outset, though, is I also have a very strong philosophy that you should never do what a speaker or a writer says just because he says it. I always tell people, I could be a maniac. You don't know that. I could be a maniac. So all I'm really doing is kind of introducing these ideas to you. You then look at the regs, Internal Revenue Code, and you look at yourself. Does that make sense? Is he wrong? Is he right? Or is there a better way? That's your job. So if you ever cite someone as authority, in my opinion, you're not a very good lawyer. Okay, you should be able to cite yourself as authority or cite directly, the Internal Revenue Code regulations or cases, not someone else's view about that case. Okay? That's a very important point. The next thing I want to mention is that it's a little bit unique about me is when I was an editor on the tax law review at NYU, and while I was there, I actually got my article published in the Missouri Law Review. So I was still a student. I was already published in the lead article in the Missouri Law Review. And I was really proud of myself. And I went to the editor-in-chief and said, look at this, I got my article published. And I gave it to him and he took it and said, oh, let me read it. And he came back. So he came back the next day and I asked him, well, what'd you think about it? And he only said one thing to me. He looked at me and he said, where was the original thought? Where was the original thought? In other words, he found the article very derivative. You're just kind of saying what other people say. Okay, but you're saying what they taught you here at NYU. You're not going beyond that. And then, when you first hear something like that, you go, wow, what a jerk, But then you start thinking about it and go, this guy's a pretty dang smart guy. And so that's been my philosophy also, not just in the estate planning books and articles I write, but even in all the other history books and things like that I write. If it's not original, like I just wrote one, just got published on the World's Fair. By the way, everything I talk about is on my website. So that's why that link is there at the very beginning. Every article, everything I talk about, it's all free. All my books are free. Okay, so right on the website, just click on them and everything's on there. So I don't make you pay for that. That's not what I'm trying to accomplish. So anyway, I just wanted to tell you that in background because yeah, I'm not going to say many things you have heard before, but when you hear it and you start thinking about it, go, there's something to that. I need to look into it. I don't need to just blindly rely on Jim. I need to look into it. Okay. So I wanted to mention that this topic today, I've already written an article on that. It's going to be published in a week or two in Estate Planning magazine. And I don't have the actual copy of it yet. It's not published, but on my website, I have the galley, the very first galley. So I did make some changes to that, but pretty much I'm going to go right down that article. But again, all these other, I also have a book on the subject. So all these are on my website. All right. Let me kind of explain why I came up with this topic. It was something that, let's just explain to Mary, something that prior to turning age 65, I'm now 66, but prior to turning age 65, I had never even thought of these things we're going to talk about today. I never even thought about it because, well, why am I talking about it now? Because I did turn age 65. And as you guys probably know, once you turn 65, you have to apply for Social Security, Medicare, and all those types of things. Well, and there's different decisions you can make, right? Like when should I take my Social Security? Okay. But also, you know, you're eligible to take IRA amounts. I could retire and start taking, is that a smart idea or a bad idea to take IRA or 401k amounts earlier than I have to? So I spent a lot of time analyzing that because I knew there had to be some overlap. You understand that between Social Security decisions, IRA, 401k decisions, even Medicare decisions. So I wanted to kind of figure all that out before I made my own elections. And I do that a lot. I did that 6 years ago before I bought long-term care insurance. I analyzed, as you probably know, there's a lot, and then it's all on my website too, but there's a lot of different ways to go in long-term care. So I decided I wanted to look at that. So I analyzed it all. And once I did, I made my decisions and then I wrote books and articles about it. Why did I decide? Okay, so that's the whole background for today's talk. Okay, so the shift, what I found is for myself as well as my clients, and you know this, you know why I know this? Because when I mention this, they all go like this. When I mention, but I'm just going to say all the clients go like this. They totally agree. Okay, and that is that once you've retired, just think about it. When you were younger and your kids were younger, you know, your clients that are younger, they only have one focus, right? There's only one focus, and that's their kids. Their whole focus is on their children. That's why they're in your office, right? They're focusing on their kids. But now when you're retired and your kids are older, everyone might have some issue here and there with their children, but let's say they're just kind of normal kids and they're doing fine. And maybe they've married and anyway, they're doing fine. Well, the reason they're doing fine was in large part due to your efforts, your and your spouse's efforts, hard work, right? In educating them, et cetera, raising them, and also hard work on your kids' part. But the point is, they're not really a concern anymore, but you start thinking about it. Now you're retired, so you no longer have a salary or an income. And we hear these clients all the time talking about, right, longevity in their family. Oh, my mother lived to 99, my grandfather, you hear this all the time, and they're in their 60s. Okay. So what should now be their major concern? Okay, it needs to be themselves. But I call it number one and number two. I always tell people this joke, and it was one of the funniest things that ever happened to me. I was meeting with a senior client and with their two kids. Their two kids brought them in. So they had never done any estate planning. They had some money and they never done any estate planning. And the kids were there and the two parents were there. And they're elderly. They had to be 90. And I remember the man the father kind of ran the meeting. And it was one of the funniest things I ever said. He looks at me and he kind of grumbles. I just want to make sure that, see, what he was worried about was he thought that we're doing everything for the kids as opposed to them. So he said that, I just want to make sure, he goes, he points at his wife and he goes, she's number two and I'm number one. And I thought that was hysterical because most clients would say the opposite, right? My spouse is number one, but no, he said, I'm number one. She's number two and they're number three. Anyway, I thought that was hysterical, but it does make you think. Okay, he was older, his kids were older, they're doing fine, right? And it's time to focus on yourselves. And great if we can help our kids in the process, great. But you got to worry. Estate planning needs to shift more to retirement planning. The retirement planning aspects. As we all know, there's like 20 different aspects of estate planning, but part of it's retirement planning. It needs a shift. So what the focus of the seminar is that it's not about investing for your retirement. I don't do that for a living. But what we can do is help financial advisors and CPAs. We can help them and our client by showing them, okay, you've done this, that's great. What can we do to minimize taxes on this? Okay, because if you can, and clients get this right away, and you guys already know this, the only relevant number is the after-tax number. The before-tax number has no relevance. It's only after-tax number. Compare a Roth IRA to a regular IRA, right? Which one's worth more? Well, this one, I got $1 million in my IRA. I got 800 grand in my Roth. Which one's worth more? You get that right away. So that's what you teach them. Okay. And so that's what this seminar is really about, is how to stretch your retirement savings so you can make it through your lifetime. And if there's any left over for the kids, great. Okay. So with primary focus in mind, I'll give you another example. My dad, who's 93, he's still alive. And when they just changed, when Secure Act 2.0 came out, and they extended the required beginning date to age 73, and then for younger people, age 75. My dad sends an email to everyone in my family. I have 6 siblings. They're all about my age, they're all about retirement age. And he says to them, look at this law, because when mother and I were younger, we didn't have this ability to defer, till 73 or 75. You should definitely take advantage of this. And even though I had conversations with him privately, just, at dinner, why that might not necessarily be a good idea. And I don't know if he's totally following. So that was my first rebuttal email. I had to first rebut my dad. And then I went into writing these articles. Okay. And so what's that rebuttal about? Well, most people, when you talk to your clients, I've yet to have a client know this rule. But most people in general just don't know this, that when you're married, okay, when I look at this is the way I explain it. When I looked at my clients and they're a married couple, I always look at them and I say, you notice how I'm looking back and forth at you. I said, that's not just to be polite. Okay. That's because that's kind of how I think of you guys. I think of you together as a couple, but I'm also looking at just one of you as the surviving spouse. Because by definition, one of you is going to survive the other. Okay, so I'm trying to not just, now that you're 65, I'm trying not just the retirement plan for you, but I'm trying to focusing on the survivor, because the rules are different. That's the point. Okay, and the first rule I talk about, is, a lot of you guys already know of this, it's called the single filer penalty. Well, in simple terms, go out and pull out the Internal Revenue Code. You'll see that with the way the law has developed now, a widow or a widower, okay, gets to the same federal tax bracket, okay, at half the income level of a married couple. Okay, so let's say I don't have the tax tables in front of me, but let's say we're talking about the 12% bracket. Okay, and let's say it was you had to have 150 grand, okay, to be in that bracket if you're married. If you were a widow or widower, that amount would be 75 grand. See what I'm getting at? You get to the same bracket now twice as fast, okay, as a married couple. And once you tell the client that, so now we're talking about, should I take early voluntary IRA or 401k withdrawals, or should I wait, till I'm 73? So my dad would just blindly say, wait till 73. See what I'm getting at? Well, just use your own brain. What do you think about that? Again, I'm not telling you what to do, and all client situations are different, but in general, okay. Now, I'm in my book, and I think it's in my article too, but in my book gives examples of situations where the married couple would be in the 12% bracket, marginal bracket, at the same level of income. The single person would be in the 24% bracket. Okay, twice the bracket. So if you just think logically, again, there's all kinds of permutations, but if you just think logically, if I follow my dad's advice, okay, my wife and I, we push as much. Remember, we're talking about a retired couple. If it's not retired, facts are totally different. I'm talking about a retired couple that this is my income. This is, we have Social Security and we have potential IRA and 401k and maybe some other savings, but that's kind of our income. We no longer have salaries. So for that couple, just using common sense, you go, okay, does it really make sense that I defer as much as possible of my 401k IRA till I'm 73 or later 75? Because if I'm doing that, the more money that I push off till I'm 73 or 75, what else am I doing? that's also that much more money I'm pushing off to my spouse, the surviving spouse, right? The less money I take now, the more money there's going to be for us later, but also for my surviving spouse. And you guys already know that it's not at all unusual, okay, for a surviving spouse to outlive the other spouse by 10 years or more. It's not at all unusual, okay, in my practice, okay, probably more than the norm. So that means you can have 10 or more years where you're taxed basically up to twice the rate, okay, as you would have been had you taken that income while you were married. Okay. And then the rest of it, I always explain, I'm not, when you talk to someone who's not thinking about this single filer penalty, they're focusing more on why should I do a Roth IRA? Because I think tax rates are going to go up in the future. Well, I don't really know. They could. Okay. And I think this, the other benefit is if I convert to a Roth IRA now, all that growth, okay, is going to be tax free. Okay. If there is growth. See what I'm getting at? I mean, those two things they mentioned, or they could happen, they might not happen. But what I just talked about is a certainty. I mean, unless they change the tax laws, that's the tax law right now. Okay. Married people, single people get to the same bracket twice as fast as married. So that's a no. So even if you assume tax rates otherwise stay the same forever and the IRA never grows, was that a good idea to convert at a 12% rate, right? Rather than have the spouse pay 24. Well, it's kind of common sense, right? Now, it's not exact math, exact science, but you get the general idea. And so that's what I teach. And so, and that's just only for retired clients. I don't know about you, but I guess I've been practicing so long, man, I get a lot of, I mean, I would say 5 to 10 a week, 65-year-old recently retired people. And so the more recent you are retired, the more you can do with this type of planning. All right. So it's not just the normal Roth conversions issues, it's these other issues that, and also that can kind of push someone over there. So if someone's debating, should I do a Roth conversion, and they didn't even know about this, but I just talked about how another benefit of Roth conversions is your spouse may be taxed at if you don't do it, your spouse may be taxed up to double the rate. Once they hear that, that's pushing you over. Okay, now that's the thing that's going to push me into doing the conversions. And again, we're not saying convert everything. You got to be judicious, right? You look at your tax rackets, but you get the general idea. And clients get it immediately. When I mentioned, they never heard of it before, but they get it. Okay, and they immediately are going to be interested in that. So what I do is I just give them my books and I say, you work with your financial advisor, CPA on this. You have any questions, let me know. And you can, again, all my stuff's on the website for free. So just give it to them and kind of goes through this analysis. All right. Yeah. So all I'm trying to say again is that it can make sense, once you're retired, and obviously over 59 and a half, to begin taking voluntary withdrawals from IRAs and over and above what you have to take and reinvest. It doesn't have to be in a Roth IRA, by the way. Okay. It can be in something, a low tax environment, dividend environment where that eventually you'll get basis step up. It can be with interest rates rising. It might be in muni bonds. It could even be in life insurance if the couple is young enough and they can get a good rate, right? That's all we're saying is it doesn't have to be a Roth IRA. It's taking money out of your tax IRA and moving it into a better environment. Okay. So in the future, and then the last thing I want to mention, we're going to get into this a little bit, but it's not the heavy focus of today's seminar, but the thing that bugged me the most and why I speak in this area, what's the unfair thing? Well, it's unfair that widows and widowers can be taxed at twice the rate of a married couple. But what's the other unfair aspect of the Secure Act? Well, it's because the 10-year rule, and the way we mentioned to clients and they all agree. I said, well, I can't tell you exactly how old your kids are going to be when you guys both die, but what we see a lot is they're going to be in their 50s and 60s. Okay, and they shake their head. Yeah, that's probably about right. And then you start thinking about what's relevant about that. Right. Well, what's relevant is they're probably going to be in their peak earning years. Okay. And what did Congress just do? What's the unfair thing they do? In addition to not grandfathering our clients, right, on the Secure Act, not grandfathering them and moving it to 10 years, they moved it to the absolute worst possible 10 years. So it would have been different if they say, oh, your beneficiaries have to start taking out after they retire. Understand that? That's not what they said. They said, no, they got to take it out probably while they're working and probably while you're in the peak tax brackets. And so it's pretty simple to explain to the clients that it means now you're adding that IRA income on top of their bracket to figure out, their new bracket. on that. It's grossly unfair. So the ancillary benefit of planning for your spouse is that if you do tax more early at a lower rate, there's also going to be that much less taxable IRA for the grandkids, for the kids, right? So it's a benefit, it's a win-win. It benefits your spouse, but it also benefits your kids. Okay. So again, we're just, my own theory is, and no one's ever disagreed with me, at least among the clients, is they get all this stuff. Once they understand that principle about the spot, what I call the single filer penalty. And, there used to be, when I was younger, everyone, you guys always heard of the marriage penalty. That's disappeared, but there was even much more significant benefits for widows or widowers. Those are really much gone, unless you are basically have a minor or a disabled child that you take care of. You don't get any special benefits. You're just treated like any other single person. And it's grossly unfair, I think. Again, when you multiply that by 10 years of unfairness, up to 10 years or so of unfairness, I just don't like it. So we can't just sit back. That's the point. We can't just sit back. We got to think, use our brains to think about it. By the way, I want to mention just why I'm thinking about it. So that article is in the June issue. I also have an article coming out in the August issue of the Estate Planning, and that's another one that addresses unfairness in the law. It has to do with paying. It has to do with the Secure Act and paying IRA benefits to a multi-generation trust, for your children, more remote descendants. So look for that one in August. But I can tell you right away, what I write about is not what Natalie Choate said. So see what I'm getting at? Why would I write it if Natalie Choate already said it? Okay, I'm kind of going beyond it and focusing more on the income taxes issues. Okay, then I talk about the different ways you can go. I talk about some issues with the proposed regs that I hope get cleaned up. But when we draft, we kind of assume, well, they don't get cleaned up, so we kind of have to draft with that in mind. But so I have like it depends upon whether you die before you're required to be getting it or after. But in each case, what I do is I talk about, if your client wants to benefit charity, what are 4 different ways to do that and not hurt your 10-year deferral type thing. And then if they want to benefit individuals, I'm talking about is contingent takers. What are 4 different ways to do that? There are 4 different ways to do that and not upset your 10-year deferral. Okay, that's what that's about. That's what the article is basically about. So it's basically taking, when I say there, what bothers me about, it was unfair to take away the lifetime deferral. So now we only got 10, but 10 still 50% better or 100% better than 5, right? And so in other words, if we can defer twice as long, it's going to reduce those tax brackets most of the time, right? So it's worth doing. And I think I even give examples of how much we're talking about. So I just want to mention that too. That's another unfair thing to look for. Maybe I'll do a seminar on that if you guys want me to. I'd be glad to do it. I just want to mention, I already mentioned this before, to the extent you save taxes for your spouse, so you end up with more after-tax retirement money for your spouse, the children are going to benefit from that too. There'll be that much more money, for the children, assuming it's not all spent. So it's, you can make sure, because that might be relevant to the clients, make sure they know that this isn't hurting the kids. What we're talking about here isn't hurting the kids, it's helping them too. Okay, so it's helping your spouse and helping your kids. Now I want to shift a little bit to taxable accounts. And so this is your non-IRA. So that's, a lot of people, that's a big part of their retirement savings is their taxable. It's not everyone, not all in your IRA. Okay. So what about your taxable accounts? Okay. And all this is the basic tenet here that all you guys do know, right, is that when you die, if you have appreciated assets, they get a stepped up basis. And by the way, we're talking about Missouri and Illinois law. In my article, you'll see I talk about community property states too, but I'm just not discussing that today for purposes of this audience. So you already know that, okay, the basic, so everyone knows that. But let me kind of take you back to when I was 25, 1982, and I was doing estate planning, and man, you're going to really think I'm old, but what do you think the estate tax exemption was? Robin, what do you think it was? You're muted. Mary, what do you think? What was the estate tax exemption in 1982 when I started? I took the class in 1979. But anyway, it was when I first started, it was 175 grand. So what is it now? 3.5 million? What is that? 20 times more, 200 times more? I don't even know. But it was 175 grand. So the point I'm trying to make is every client, every married couple client did 2 trusts. Why? because you wanted to at least get 2 exemptions. By the way, the rate was as high as 70%. And we had a Missouri estate tax too. So everyone did 2 trusts. You had to, okay? Because if you wanted to get at least 2 exemptions, then it gradually went up to, 600 grand and stuff like that, but still not that much. So everyone did 2 trusts, okay? And whereas today, a lot of people are doing joint trusts. And what I'm going to get to is, I'm thinking that maybe for a lot of clients, they should go back to 2 trusts, or at least 2 shares or 1 trust. I'll get into that in a second. But the reason that we did all that was because we had to, for estate tax reasons. And we talked about a lot of the other issues. But when we were funding those 2 trusts, so let's say we were at the 600 grand exemption, okay? And we're funding those. At every single meeting, we talked about, so the client had taxable assets. We talked about which trust, where should you put which assets, right? You don't hear that much anymore, because most people just have 1 trust. But back then you had 2. So the discussion was always, well, maybe we ought to put more of the highly appreciated trust in the assets in the man's trust because he's more likely to die first, right? I mean, that was a significant discussion, okay? So I just want to let you know, we discuss that all the time. You almost never hear it today. What I'm going to suggest here is maybe we need to start discussing that with clients that have any kind of significant amount of appreciated assets, okay? So you got to start focusing on it, and why. And the reason for that is that if you own an asset, there's a real simple basic principle. So I'm teaching the basic principle, then you'll see how I'm applying it. You guys already know this basic principle that if I own my assets jointly, okay, as joint tenants, and I live in Missouri or Illinois, there's a 50% basis step up, right? When the first spouse dies. So 50% of the gain is wiped out. That's the glass half full view, okay? What's the glass half empty view? That means that every time my surviving spouse sells an asset, right, there's going to be gain on, even if it's right after my death, there's going to be gain on 50%. See that? Now compare if you live in a community property state. You guys already know this, that you get a whole 100% basis step up on community property when the first spouse dies, and it doesn't matter who owns it. So I'm not getting into gimmicky things that create basis. That's not what I'm talking about. I have written articles on that, but that's not what today's about. Today's talk is just about, okay, I have these taxable assets. How should they be distributed between the funds? Okay. So the other thing I want to mention just really quickly, and it's kind of a hybrid of these last 2 issues, is that you have a surviving spouse, remember, subject to the single filer penalty. What assets should she be using to pay tax? Well, I just kind of mentioned that normally it's better to take, in that example, if you didn't have any other basis stepped up assets, it's better to, most of the time, to take non-taxable Roth IRAs than take taxable, because of the whole reason that, well, you're subject to the single filer penalty. And maybe your kids, say, are filing jointly and maybe won't have to pay that. So it's just something to bear in mind. Doesn't always apply, okay? Because in some situations, it all depends upon your kids. And they may say, well, that's not my situation. Maybe their kids are, my kids are total bums. I had one person actually said that the other day, 3 or 4 kids, and they weren't even that old. They're in their 20s. And she said they're all bums. And she actually said that to me. Most parents, most clients don't say that. But my point was that, well, you got to look at that and just say, well, maybe it all depends, right, on what brackets they're in. So it could be the opposite. Your kids are tremendously successful, and you got to look at your single filer penalty tax and say, okay, that one, even though I'm filing the single file, I'm paying a penalty, it's still way lower than my kids are going to be. See that? So you just got to look at that fact. So you ask about the kids, and you don't get into intimate details, but just generally, how are they doing? And the clients get this. They understand this whole math thing. Your tax rate, basically, it's your tax rate versus the approximate tax rate of your kids. That's simple. Okay. Now back to purely the basis thing. So we're talking about the concern, the retirement planning concern is, what if my spouse is going to need to sell some of these assets, not the taxable kind of assets, for retirement? Okay. Well, of course, if possible, we want the spouse to only sell assets that have a stepped up basis. My spouse, so they have to have little or any gain, right? That's the goal. Okay. So that's the ultimate goal. We definitely don't want he or she to pay taxes on zero basis assets, and once it did no step up. But the next worst thing is joint assets, because they only got a 50% basis step up. See that? And here's where we're going to come into some unique things about Missouri law that really help. So what I'm suggesting is that people think about taking their accounts and using two trusts, but in Missouri, you'd use 2 shares of a spousal asset trust. If I was teaching you at SLU Law School at Villanova, I'd ask this questions: why would I do that? You know, why would I? If you lived in Missouri, why would we use a 2-share qualified spousal trust as opposed to just divide the assets into 2 trusts? Well, the reason is when you divide joint assets, right? Tenancy by entirety property in Missouri, you've just exposed them to lawsuits. Okay, but in Missouri, you don't have to do that because you can use a qualified spousal trust with 2 shares. In our draft, and we just call them share H and share W, husband and wife, and put the asset, you know, roughly half of the appreciated assets in each share. Okay, so now you've got basis step up. I mean, you'll get basis step up on part of that, but also you protected those assets from lawsuits. Okay, so consideration should be given to dividing appreciated assets between 2 spouses in Missouri in a spousal access trust. And here's why. Okay, because now one spouse dies. One spouse is going to eventually die first. And it's going to have IRA monies and things like that, you know, to use for retirement and maybe some of these other these taxable assets. Well, wouldn't it be better than to automatically, every time she sells or he sells an appreciated asset, to pay 50% gain, right? And 50% gain reportable? Wouldn't it be better? So if the wife survives, wouldn't it be better for her to first sell the husband's assets, okay, that received 100% basis step up, right, before she sells any of hers? So she'll be selling all these assets tax-free, and to the extent she still has assets when she dies, they'll get a basis step up to the kids, right? So you kind of effectively getting community property green status. And that's also one of the, that was one of the first things I noticed that was unfair when I took these courses at Notre Dame, was how unfair is that? That if you live in a community property state, your spouse gets 100% basis step up no matter who owns the asset. But if you live in Missouri, I was in Indiana, okay, you don't get that. It's unfair. So we have to figure out ways. So this is, to me, one of the best ways to accomplish that without doing a gimmicky thing. You know, there are a lot of gimmicky techniques, but we're using joint trusts, and there's questions whether they work. You know, if you look at the IRS rulings, again, I've written on this if you want to read more about it, but this way actually works. Okay, so and the reason it works so well in Missouri is because we have the qualified spousal trust. See, if you're in another state, there's only about 2 or 3 states that have this law. If you were in another state like Illinois, you'd have to think twice about that because you've exposed the assets to lawsuits. You understand that? Because you took them out of joint names or tenancy by entirety form and you exposed them to lawsuits. In Missouri, you can have your cake and eat too. And I've written a lot of articles on this. Okay, they're on my website. Okay, all right, everyone kind of get that, I hope. So the idea is to roughly divide them, and then but then what you do is you say, okay, what happens when one of the spouses dies? Well, we're worried about lawsuit protection, not just for the couple, but for the surviving spouse. And we're worried about divorce protection, et cetera. So you have those assets. I call it a bypass trust, but you can call it whatever you want. But it's a trust for the surviving spouse. So if I die first, my appreciated assets got a basis step up. They go into a trust for my surviving spouse, okay? And they can still be sold tax-free, okay? But those assets are not protected from lawsuits, and also if my spouse remarries, potentially from claims of a surviving spouse. You understand that? So the point I make in a lot of my articles is, even if you're not subject to estate tax, there's a lot of benefit of using 2 share. And we are uniquely positioned in Missouri to be able to do the 2 share approach and not expose assets to lawsuits because of the qualified spousal trust. Okay. And again, I have all kinds of articles on this on my website. Just make sure you understand how the website works. It's not going to list the articles. There's different links. You click on the link, like might be a link on retirement planning. And you click on that, and then all the retirement planning articles or webinars, will be on there. This is another important point. I think this is really important. I have this right now. Okay, I just got a call a couple of days ago from a woman, and her husband just went on hospice. Okay, and he's got a pretty big estate. So what can we do about that? Okay. Well, just kind of teaching the base. So a lot of people say, well, if he's on hospice, let's put all the appreciated assets in his name and get 100% basis step up for the widow, right? And right at the outset, I want to mention, this is obviously a really hard discussion to have. You don't want to have this discussion, with the widow. I find it actually sometimes easier to talk to the kids about it and let them talk to their mom about it. It's a pretty hard discussion to have. Your husband's dying, so it's no, because you don't want to. I don't like to discuss that. But if they bring it up, anything we can be doing, see what I'm getting at? And then she did. Then I talk about it. Okay, that's kind of how it works. All right. So any event, there's a rule that you might have heard of. It's under section 1014E of the code that if I make the general rule is that if I'm the widow to be and I transfer appreciated assets to my husband, okay, and I do that within 1 year of his death, and the assets come back to me, you don't get basis step up. Okay, that's just the rule, because obviously, if you did, and it would be people would be doing it all the time, and now that is kind of a fair rule. I actually think this is a fair rule, but what we got to do as estate planning terms is there any way around it? Well, again, there's a lot of gimmicky things. Again, I talked about all these things, but the system I've used the most, and it's always worked so far, is that what you do is you don't have the assets. Remember, we don't want the assets to come back to the spouse anyway, right? Because we want them to be estate tax protected, lawsuit, divorce protected. So we want them to come back to a trust for the spouse. The issue is, how do you draft the trust? Because if you look at the legislative history, the 1014E, what it says is, it doesn't say you don't get a basis step up if it goes to the spouse. It says the legislative history, and the code says this too. It says, to the extent the asset comes back to the original transfer, to the extent it does, you don't get a basis step up. Understand that? So what you do is you draft this trust, and you draft it like, I think you guys have probably had exposure to supplemental needs or special needs trust, where you kind of take away the rights of the beneficiary. I mean, it is for the person's benefit, but they have no legal rights. Okay. And that's basically the way we draft. And so the bypass trust would create no rights in the spouse. You also want to put the kids on as other beneficiaries. It's probably even best to have a different trustee. Like in this one case, they had a friend, a real good friend was the trustee. Okay. So what you're doing is basically trying to minimize or eliminate the actual rights of the spouse in that trust. So therefore the 1 year rule doesn't apply, or at least it's minimized. Understand all that? So you get the general idea. And the reason I use this, I just want to give you this analogy. It's not a special needs trust. It's not exactly how I drafted it, but the concept is the same. Take away legal rights in the spouse so that she can argue it didn't come back to me. It came back to all these people could benefit. All my descendants could benefit. Understand it? And I don't even have any rights. I can't. It's drafted so that the independent trustee has sole and absolute discretion. So this one that we did, oh gosh, we did it 10 years ago. It worked fine. We basically put all the appreciated assets, and then we had the IRA payable outright to the wife. So the IRA, she has that, and then all the appreciated assets are trust for a benefit. A little bit about Social Security. I want to make sure everyone knows that I'm not talking about, the reasonable minds can differ. Is it better to take my Social Security, at early or at normal retirement age or age 70? That's not really the discussion I want to make here. My point is that you just need to know, and again, the reason I'm mentioning this, I didn't know all these rules when I was 40. I know them now that I'm 65, but I didn't know all these rules. I didn't know them real well, I'll tell you that. But the basic rule is that if you basically have no other income, okay, Social Security is tax-free. Okay, but once you start having almost any income, okay, it's either going to be 50% includable in your income or 80 up to 85% includable. And I wouldn't doubt the rules would change even more. Okay, so that's the rule. So basically, if you start having any kind of significant income, at least either 50% is going to be taxable or 85. And so the reason I'm mentioning all this is a possible exception to what I was saying before about, hey, it's a good idea to take your IRAs early. That is true, unless you're in this case. See, for example, for me, I'm not in this case because I'm going to still be working. I got income anyway. Understand it? But I have a lot of clients. I'm not with you, but you ask them, they say, "Oh, we basically live off of Social Security." Great, because they got everything paid for and they don't go on many vacations and stuff. Well, if that's that person, you start thinking about it. Well, if I, and that for that person, maybe it's better to wait until 73 to start taking my IRAs out. And let's say I'm 66 and a half now. Okay. And that's when you have to start, for me, that's when you have to start taking Social Security. So maybe for those 7 years, okay, I won't take any IRA money out because now I got 7 years of tax-free Social Security. Understand that? If I had taken it out, yeah, I might get a benefit in the long run, but in the short run, I didn't. Okay. Because now I made Social Security taxable when it wouldn't have been otherwise. So I'm just making sure we in our firm, we represent all clients. It could be the grandma that has almost nothing, and we have one client that's worth $1 billion. So that we represent all clients. So you have to tailor your recommendations to the clients. And I just want to make sure you know about this because I get a lot of clients that say we live off our Social Security. Okay. So again, although the normal thinking that we were talking about earlier is take the money out early, that might not necessarily be the case. Now, once you get to be 73, then it's moot because you got to take the IRA out. Okay. And at that point, you come back to the same question. Well, now I'm 73. My question now is not should I take the IRA out because I have to, is should I take out more than the minimum? That's the analysis. Once you're 73, then it's still the analysis we just talked about still applies. It's just that it's not whether I should take it out. It's should I take out. That's why I always use the term voluntary. Should I take out voluntary, which voluntary means more than the minimum. All right. And you run the same kind of math. Okay. Next, we've already touched upon this, but I think this is really important. If you look at my website, so I list like the 10 or 12 areas of estate planning that we all do. And I didn't list them in alphabetical order, but the first one on the list is asset protection planning. Okay. And I've written a lot in that area. And the reason for that is that if we can't protect our clients' assets from losses, right? And this could all be moot. There won't be any assets, left for the spouse or the kids. I had one recently where we did a qualified spousal trust, and had they not done it, the husband got in a car accident, died, killed 2 people. I don't know if you know the average recovery if you kill someone in a car accident is $4 million. So that was an $8 million lawsuit, which would have wiped out the spouse. Okay. But because we did the qualified spousal trust and fully funded it, you got to fund it. Okay. There was the recovery was zero. And by the way, this lawsuit wasn't even in Missouri. It was in a state out west. And the judge honored Missouri law. Okay. So it's just something now it was, I always tell people if you didn't see all my articles, fortunately, it was in a tenancy by the entire state, which I think helps. You get the recovery you want. And there's only about 20 tenancy by the entire states. Florida's one is a tenancy by. So my point was, I just want to make sure this was the suit was in the state out west, and our Missouri client won. And all the judge wanted to do, I just did a memo write up about Missouri law. And he looked at it and researched it and went to it was actually it was a arbitrator, and the arbitrator looked at it and went to the plaintiff's conference room and said, I'm sorry. And by the way, our client widow felt so bad about it that she ended up giving him a couple $1 million, even though she didn't have to. She just voluntarily gave it to him. She said it's just wrong, that they don't get any kind of recovery for this. He didn't have any umbrella insurance for some reason. Okay, so that's another important point. These qualified spousal trusts and other techniques, they protect your assets, but you don't protect your income. So, if you have income coming out, and I'm going to touch on that next in this area, if you have income coming out, that can still be subject to lawsuits. Okay. So I'm just trying to mention that owning assets, you got to remember this point that owning assets as tenants by the entirety of Missouri is great while you're married, right? Both spouses are alive. Okay. But once one dies, there's zero protection, right? There's none. So that's what's so great about the qualified spousal trust in dividing the assets is in addition to the basis stuff up, we can get creditor protection in Missouri. Okay. And by the way, for you new guys, there's also another technique. It's called the Missouri Asset Protection Trust. I have a lot of articles on my website about it. Is how do you protect a single person? So how do you protect a widower from lawsuits? And another unique law in Missouri, and you need to at least talk about it. We talk about it with every widower, and it's in our nature engagement memo. They have to sign off. We talked about it. That was an option. You could have done this Missouri Asset Protection Trust. This isn't a seminar on that, but read up about it. Let me know. By the way, if anyone ever has any questions, you just email me. My email is right on the website. I don't care. I could get 1,000 questions. I do not care. I'm here to help teach. It doesn't matter. You can I'll email me at 10 o'clock at night. You're probably going to get a response. Okay. So don't be afraid to do that at all. This is an interesting point, though. Again, something you don't hear much about, but there's an additional advantage to converting to a Roth IRA that you don't get with a regular IRA, okay? And that is, remember, in general, IRAs and Roths are protected from lawsuits in Missouri and a lot of states. They're protected from lawsuits. Yeah, but not the distributions from it. Not the required distributions. They're not protected. Now, that's just going into your bank account. You understand that? And, people can garnish those and, and get at those assets. So what then, as you think about it, what's the additional benefit of a Roth IRA? Well, as you know, Roth IRAs don't require distributions during either spouse's lifetime. If you do it right, during either spouse's lifetime. Okay. So if you get sued, the Roth IRA is protected, and because there are no required payouts from it, it stays protected. Where if it's an IRA, let's say the RMD is 100 grand a year, well, that 100 grand a year is free game, subject to some other rules. But that's another additional benefit of converting. Okay, when you talk to your clients, in addition to all these tax things, that's another additional benefit. I don't know about you guys, but my clients, I would say 95% of them, and I have 4,000 clients. When they come in here, 95% of them, you look at their balance sheet, the numbers aren't the same, but this disparity is the same. Mostly it's their IRA, 401ks, Roth IRAs in their home. They have some other savings, but unless they inherit a bunch of money, why don't they have a bunch of other money? I always tell people it's called kids. Yeah. I mean, you don't have any money because you're doing all these things for your kids, but you have your retirement account. They have some, but otherwise, or they just, we're successful. But I'm talking about 95% of people, or business owners, another exemption. So my point is, that's why we focus so much on. I just went to a seminar last week. It was the Planned Giving seminar downtown. It was at Forest Park, which is my favorite place, and it was at the Visitor Center. And the first sentence, the speaker was from Indianapolis, and she's speaks on charitable giving techniques, planned giving techniques. And the very first thing she said, actually everything she said at the very beginning, I totally agree. But the major thing she said was, "Oh, you think the estate tax is gone, don't you?" For most people, this is what she said. And she said, "You ever heard of the Secure Act?" And she's just talking about, all it happened was it got replaced by a huge tax on IRAs and 401ks. And that's where most of our clients have all their money, right? And that happens within it's just basically a 10-year payout of the estate tax, right? And she's right. She's speaking in English. And so that's where your planning has to be. I totally agree with that. So hope everyone understands that basic concept. Yeah. And I mentioned the bypass trust. Oh, this is something too that I think is overlooked, and it needs to be discussed in light of the Secure Act. And that is that generally in estate planning, you always would pay your IRA or even Roth IRA outright to the spouse. Why? Because the spouse can still get, even after the Secure Act, can still get lifetime deferral, right? But if you pay it to a bypass trust for the spouse, the maximum deferral is 10 years. So normally you'd say, okay, then we shouldn't pay it to a bypass trust. But my comment on that is that you're only looking at one issue. Remember that one of the main reasons that we paid IRAs outright to the spouse was not just that the spouse could get deferral, but that would then qualify the kids for deferral over their lifetime. So when the spouse dies, whatever's left in that IRA or rollover IRA, the kids could defer over their lifetime, right? But that's gone. Okay. So one of the major benefits of paying IRAs to a spouse outright is gone. Okay. So now what's the benefit versus paying it to a trust? Well, it's the spouse can get deferral over his or her lifetime. The trust can only get 10 years, right? That's basically the rule. But just think about it logically. As that spouse gets older, as you get old, the couple gets older, that gap, okay, between 10 years and the life expectancy, basically it's life expectancy. That's not exactly how it works. You get, but the point is the gap narrows. So you can look at it sometime and say, well, if I paid it to, I'm just giving you an example. If I paid it to my spouse outright, it would be 15 years under the IRS tables. Okay. If I paid it to a trust, it's 10 years. Okay. In other words, you get to a certain point and that gap starts narrowing and you're going, boy, I'm giving a lot up. I may be giving up estate taxes, right? By paying it outright, but I'm definitely giving up lawsuit protection and other things. So we look at it all the time. We don't blindly anymore. We do not blindly. And by the way, it's not all or nothing. You might say, okay, well, let's pay half of the IRA to the bypass trust and half outright, just giving you examples. So it's just not the automatic, basically the automatic rule was in years past. In the last 10 minutes here, I want to talk about two other things. This is an important concept. And even if I try to explain to clients, they get it right away. Even if you do everything we've been talking about, do all this type of planning, there's still going to probably be some taxable IRA or 401k money left when the couple gets older, right? There just is. You're not going to get it all out, because in order to get it all out, you have to pay real high tax rates. So there's going to be some out. All I'm saying is, if when it comes time and you need the spouse or the surviving spouse needs to pay long-term care expenses, okay, custodial care, okay, this may be the best asset to use as opposed to other assets. So, you don't want to use other assets because they're going to get a basis step up when you die, right? And all the gains wiped out. But if you use taxable IRA assets to pay your long-term care, well, I think most of you know that long-term care is subject to the 7.5% floor rule. It's fully deductible. Long-term care expenses, like if you're at Del Mar Gardens, stuff, that's basically fully deductible. So if it costs $100,000 a year, understand that, and you pull $100,000 of your IRA out a year and you send that to the nursing home, all but the first 7.5% is going to be deductible. So eventually, essentially, what you did was you turned your taxable IRA into a tax-free IRA. Understand that? And some of these people could live a long time too. So that's just a no-brainer, as opposed to using, Roth IRA or a taxable account that's going to get a basis step up. To be smart about what you use. So again, all it is, take advantage of what we can. Just be smart about it. Okay, minimize the taxes. Last thing, and by the way, I have a whole separate article on this topic. It was published in wealthmanagement.com, but it's on my website too. And this is what this is all about. Was I'm on a planned giving committee at a charity, and we're just trying to think of new ideas. And I started thinking to myself, when right after the Secure Act got passed, I wrote a book. I wrote 2 books. They're on my website. Again, they're all free. One's called Estate Planning for the Secure Act. One's called Estate Planning for IRAs and 401ks. And what I talked about on the Estate Planning for the Secure Act, I went over all the possible things you could do to minimize that tax. And one of the things I explored was paying IRA money to a charitable remainder trust. Okay, because as you know, a charitable remainder trust, at least initially, is tax-free. Okay, so so the issue was, could I come out ahead by paying the money to a charitable remainder trust, pay an annuity to my kids for a period or for life, and then have it go to charity? Would I come out ahead? Okay, well, when I ran all the math on that, because interest rates were so low at the time, they got down to, you probably remember, they got down to 0.4%. I think in November of 2020, 0.4, because interest rates were so low, it just didn't make sense. You were going to come out, you were really going to hurt your family. So I want to benefit. I'm not talking about the person that just really wants to benefit charity. I'm talking about someone that wants to benefit family, but also I don't mind benefit charity in the process. Okay. Well, today, so what I decided to do was, how would I analyze it today? Well, in April, when I wrote that article, it's called the 75-20 rate. Again, it's all in this article that's on the website. The rate was 5%. So I reran it at 5%. And I determined that it made a heck of a lot of sense. And here are the reasons why. And they're all outlined in my article, but on here too. Okay. First place, the IRA, the charitable remainder trust can go 20 years. If you do one for a period of years, it can go 20 years. And IRA has to now be paid out over 10. Well, what does that mean? Well, so I'm adding another 10 years to the payout. In other words, the IRA money comes into the charitable remainder trust tax-free, and then it's paid out, basically 90% of it is paid out, because you have to pay out 90%, no more than 90% to your kids. So 90% of it's paid out to the kids over 20 years, not 10. So what does that mean? Well, again, think about the average age of kids when you die. Well, let's say they're in their 50s or 60s. Well, so the first 10 years, they may still be working. Okay. But the second 10 years is a good chance they're not working. Understand that? And so the second 10 years after you died, there's a good chance they're going to be in a much lower tax bracket than they were during the first 10. So the idea is that you shifted half of the income into much lower tax rate years. Okay. Right away, you can start seeing that. Yeah, I can see how that, even though the charity has to get 10%, I can see how our family still comes out ahead. But there's one other rule that's really important. And that is that this is another unfair rule, and this is why I love this charitable technique, because it plans around this unfair rule. The unfair rule is that, let's say I have $1 million IRA and it's paid out over 10 years. Well, every penny that comes out of that IRA, including all the post-death growth in it, every penny is taxed at ordinary rates. So it doesn't matter if you invested in stocks, that pay dividends or would have had capital gain rates. It doesn't matter if you invest in tax exempt income. When that money comes out of the IRA, it's all taxed at ordinary rates, the highest rate. That's not the way a charitable remainder trust works, okay? If you invest it properly, and the article gets into this, here's how a charitable remainder trust works. What you pay to the charitable remainder trust when you die, let's say it's $1 million, that comes out of the ordinary rates, okay? But all growth in it, okay? And so my example, the number would have been 100, if I put 100 grand in, the first 100 grand would be taxed at ordinary rates, but the beneficiaries would have received 144 grand. That's just what they would have received over the 20 years. So that 44 grand, see, is eligible for dividend rates, capital gain rates, and tax exempt income rates. See that? So you add that fact, okay, to the fact that you've already spread it out, got maybe 10 years into the retirement years of your kids. You don't have to be Einstein to figure out. That's something I would at least look at. Okay. And one other thing, this is aside, but the very first thing this woman said at the seminar, it was so insightful. Like, wow, that's such a good point. And I'm going to start telling all my clients this. She goes, is there any reason why, can you think of any reason why any of your clients, if you said to them, what about just giving 1% of your IRA when you die to charity? Just talk 1%, just 1%. Okay. It's like nothing. Remember that 1% would have been taxed. It's like nothing to give 1%. But if everyone just did that, just gave 1% of their IRA to charity, it has like almost no effect on your family, right? But that really adds up for the charity. I thought, man, that's a really good point. And so I'm going to tell it to clients. They don't have to do it, but I'm just going to say what she said. Okay. So anyway, you get the idea. So it's worth looking at the math and all this stuff. Does that make sense? Because a lot of clients will love it because they'll say, but you're saying, so my kids are going to end up with more money on this thing, but the charity is going to get 10% actuarially determined. They'll get more than 10%, but on a present value basis, they get 10%. I like that. That's a win-win. And the only one that loses is the IRS. And one of the main reasons they're losing is because you're spreading the income into lower tax bracket years, right? And you're also qualifying the growth for these special tax treatments. Okay. So that's a technique that I think is worth talking about. I have a whole separate article devoted to that, but I wanted to put it in this discussion because what this is talking about is, the last thing I talked about was when you're much older, using money for long-term care. Okay. This is, okay, now I'm dead. Okay. Now, eventually I'm going to die. And how can I make, stretch that more, make it worth more to my family and to charity. Okay. So I think everyone gets all that. Again, the major function is, so you got to pay attention to the 75-20 rate. I think it went down to, you guys probably know, but I think it went down to 4.4% in May. I'm not positive, but it was at 5% in April. And that's it, unless you have some questions, but you guys can all, I don't know how you're set up, Mary, on that stuff, but they can also email me any questions they have.
Yes, any quick questions for Jim while he's here?
You got to be off mute, right?
Yes. So I don't have any requests to unmute.
Okay. Well, thank
Thank
you
you
much.
so
I enjoyed
much,
doing
Jim.
it. I enjoyed
We
it.
appreciate you sharing all of your ideas with us. You certainly gave us a lot to think about. And as a token of our appreciation, the Estate Planning Council of St. Louis would like to present you with an award to show our appreciation of your presentation in our 2022-2023 Young Professional Speaker Series. And we'd like to present it to you in person if you're available on May 22nd at our next monthly meeting.
I'll write that down. I'll let you know.
All right, and as a reminder, this has been recorded. We'll follow up with the recording and the slides. And thanks everyone for attending. We hope to see you at our upcoming happy hour on May 17th at Peelwood and Clayton. Thanks and have a great rest of your day.
Thank you guys. Bye-bye.
Hi, Jim. Thanks.
You're welcome.